Good afternoon, Mr. Aguilar. And are you counsel, owner, manager, agent?
Representative from
Okay.
and
owners
then
of the company
Zach's one of the owners.
Yes,
Okay.
owner and employee.
Fantastic.
Agent.
Representative and owner. All right. And do I have someone here on behalf of the defendant? Oh, just lost it here. Hi, Guy Aseline.
Yes, I'm here.
Good afternoon, sir. Thank you for being here.
Quick
right.
question. I'm not the one getting evicted. I don't live in that house.
Sir,
I think
Mr. Aseline, we're gonna cover that, but your name is the titled defendant. So I'm glad that you're here because the plaintiff has to establish that you are a tenant or that you are responsible under the lease. So let me first ask questions of Mr. Aguilar, okay? Mr. Aguilar, what is the reason you filed to evict the defendant?
So we were the lender in the situation. This was an investment property by the gentleman in question and one of his business partners. We foreclosed on this property, I want to say April 7th of 2026.
All right, was the defendant the person who was foreclosed upon for default?
Correct. Him and his partner.
Mr. Aseline, is that correct?
yes, ma'am.
Was this property foreclosed upon?
Yes, ma'am. It was foreclosed.
All right. All right, Mr. Aguilar. Are you seeking anything besides possession today?
Just possession. Yes, ma'am.
All right. When was the purchase completed?
Foreclosure went through on April 7th, 2026. And then we delivered a change of ownership on April 8th of 2026, and we placed it on the front door.
All right. Did you provide the defendant with the notice to vacate as a result of the foreclosure?
Yes, ma'am. We placed it on the front door. We taped it, took a photo, submitted that photo over to the court as well. I can share my screen. I have it in front of me if need be.
All right. When was that notice delivered to the defendant?
April 8th.
To your knowledge, did the defendant receive that notice?
Yes.
All right. Mr. Aguilar, are you aware if there are any tenants in the property?
If I know if there was any tenants, from my understanding, it was one of the partners that was living there. Partners of the LLC that signed on the loan docs.
So there was a tenant or an occupant?
There was an occupant.
Who is that?
One of the partners, either gentleman, I can't pronounce his name.
Mr. Aguilar, let me ask a question then, because
Mhm.
are you wanting to evict the occupant or just Mr. Aseline?
The occupant. Yeah, because we took possession back on the 8th. Sorry, ma'am.
You did not include the occupants in your petition. As a result, if you win your case today, you're only able to remove Mr. Aseline.
Well, from my understanding, he was the one that was living there, and we had no communication with him, nor whoever was in the property. They never called us.
They're not required to, Mr. Aguilar.
Go ahead, ma'am.
I'll ask you again. To your knowledge, other than Mr. Aseline, are there any tenants or occupants in the property that you're trying to evict?
Yes.
Then what I'm saying legally is that you can win today with Mr. Aseline, but your writ of possession would be ineffective against any of the occupants because you did not include them in your petition or your notice. Is this really the case you want to move forward with? Will that get you the thing that you were trying to accomplish? You have to include all occupants or named tenants. Just evicting Mr. Aseline will not get you the relief you're seeking.
Your Honor, quick questions. On this loan, like we are not ever a landlord. We don't have a lease.
I understand that. The Texas Property Code is very clear, though, about what the process is for foreclosures. And in any eviction, even if it's one related to foreclosure, the writ of possession is only effective against parties that are named. So if you did not name the occupants or the other tenants, you're not going to be able to get rid of them. You're going to have to do this again.
Yes, Your Honor. Does that for squatters? Is that the same?
I'm not able to hear you, sir. It's a little bit hard.
Oh, sorry, Your Honor. For squatters, is that the same set of rules? Because that's what we're.
It sounds like you're not a squatter. If he's there at the permission of Mr. Aseline, please call a lawyer. Please call a lawyer. I'm not gonna give you advice as to what your situation is. I'm just saying right now.
If you don't mind me saying, it's not under my permission.
Aseline, you don't need to speak. You're winning your case. Well, actually, that's not true. You're losing because they've got a foreclosure. My point is this to the plaintiffs. When you file your eviction, you've got to name the people who are in possession or who you wish to remove. You only sued to evict Mr. Aseline, but you've told me in testimony that you're aware of there being an occupant.
We think Mr. Aseline is the one.
Your Honor, if I may speak,
Who's that?
Mr. Lofton, my name is Phil Guimond. I'm the actual
Sir,
occupant
sir.
of the house.
And that's fine, but you're not a party to the case. I'm still hearing from the plaintiff, so please be silent for now. Mr. Aguilar, I'm back with the plaintiff. For the Lone Ranger, I'm just asking y'all, it's your case, we're here. You only sued to evict Mr. Aseline, and per what he said, he doesn't actually live there. He's just the person who got foreclosed upon. But you're aware that there's someone physically present in it, and you didn't include them in your petition.
So I'm not aware who the tenant is. From my understanding, it's Mr. Aseline. I've never met him in person, so.
Well, Mr. Guimond just identified himself. He's been contacting the court. Right? And there are ways in which you can go about it if you don't know the name of the person who is occupying the property you're trying to regain possession of.
Yeah, okay, thank you, Your Honor.
Here's the thing, I'm trying to give y'all heads up. You can win your eviction, but the thing you're wanting to do, which is remove Mr. Guimond, you're not going to be able to do because your order didn't include him or the occupants.
Okay, understood.
So that's what I'm trying to get. So Mr. Guimond, I'm not trying to cut you up. I'm saying that they can't remove you because they didn't include you. There is a breakdown in the legal function that's taking place here. I understand what all parties are trying to do. I'm pointing out a legal insufficiency in your pleading, Mr. Aguilar, on behalf of Lone Ranger. If the goal you have is to be able to evict and remove all occupants, your pleading as it's put down is not going to get you there. And you can't change it today.
Okay. So my question is, if it's this gentleman, Philip, who's Guimond,
we do know him. He's one of the partners of that LLC.
Okay.
We do know him.
So Mr. Philip is the one that's living on the property.
Hey, Mr. Aguilar, you're fading out. I can see you chatting, but I'm not able to hear you.
Can you hear me, ma'am?
Yeah, that's better.
Okay, so then the occupant, I'm assuming, is this other gentleman here in court today.
Correct.
So he is one of the partners on the LLC, and they signed an affidavit stating that since this is an investment loan and investment property, that they can be used as a homestead. They both signed that document there as well.
That doesn't change what I'm telling you about how it's legal to evict someone.
Mm-hmm.
All right. You have to name tenants and occupants if you want to be able to enforce a writ of possession against them. You didn't name anyone except Mr. Aseline. So I'm highlighting for you information that may be useful to you to determine how you want to proceed with your case.
Gotcha.
So now I'll ask you again, on behalf of Lone Ranger, what would y'all like to do with your case? Knowing that you have sued Mr. Aseline is here and he's here and we can move forward with that, but you also have been given information about Mr. Guimond, an occupant who is currently presiding in that property.
We may as well move forward.
Yeah.
Your Honor, we'd like to move forward just to cover all bases in the matter that it comes back.
All right. Mr. Aseline?
Yes,
You're on mute, sir. Good. Well, welcome back. Okay. So Mr. Aguilar is here and he's told me that as an agent on behalf of Lone Ranger, and I think there's been established and you've acknowledged that the property has been foreclosed upon. Mr. Aguilar says that he's provided a notice. That notice would be effective for you and, well, it would be for you here, and that's why we're here. Is that correct, Mr. Aseline, that Mr. Aguilar, the property has been foreclosed upon somewhere around April 7th or April 8th?
Yes, and they notified me the same day. I knew it before because we were led there by Mr. Phil Guimond.
Okay.
And I'm aware of it. Also, Phil was aware of it, and he didn't want to leave the property. So we're not on that side. We're trying to evict the property ourselves. We want to be out of it.
All right. Well, here's where I can give everyone some information. So the judgment today would be a judgment of possession on behalf of the plaintiff, Lone Ranger. I do need to determine an appeal bond, and I need to set an amount of monthly rent. For the state statute, because there was no lease agreement between the parties, right? Mr. Aseline never agreed to pay any type of rent to Lone Ranger. This is a different situation. The court would put in the minimum justification, or kind of there's a new statute there, so I would put in the monthly rent amount as $250. That is the minimum that's required by the statute. And then I do need to determine an amount of appeal so that the award would be possession and your cost of court. There's no monetary judgment on behalf of the eviction. So Mr. Aseline, you don't owe any money. It would be an award for possession. The amount of money that's awarded is a very small amount. It's the cost of court, which is typically about $130. I do have to set an appeal bond though, and typically we would set the appeal bond if there had been monthly rent. I would use that. I'm just curious, Mr. Aguilar, do you know what the monthly mortgage amount had been for this property?
It, what was it going on there? Like eight.
It was roughly 7,000, the market rent.
Yeah, so monthly loan payment was around 7,000, market rent's around 5,500, around there.
Is it a commercial or residential property?
Residential.
And what size is it? Or what type of property?
It's a single family, one story. I'm gonna
What's
say
the
it's
square
either,
footage?
let me verify that real quick, ma'am.
1,800.
There we go.
300
Thanks,
square
sir.
feet. What kind of acreage is it on?
I believe it's close to a quarter acre.
About a quarter acre, ma'am.
About a quarter of an acre.
Mhm.
All right. I'll put the appeal bond at $1,500. All right. Now, Mr. Guimond, I recognize that you are not a party to the case, but you are someone who might have an interest in the outcome. So I'll just give you a bit of information, okay, sir? You're not a party to the case, but again, I understand that you may have an interest in that situation. So I'll give you information, the same thing as Mr. Aguilar and Mr. Aseline. The judgment today is a judgment on behalf of the plaintiff for possession. Either party can appeal. When I say party, I mean that sincerely. Mr. Aseline or anyone on behalf of Lone Ranger has the right to appeal. Depending on the outcome of whether people appeal, plaintiff can receive a writ of possession. The writ of possession can be issued at the conclusion of the appeal period. So if no one takes any steps after 5 days, on day 6 is when a landlord can seek the writ of possession. Now, the writ of possession would be issued against Mr. Aseline, and so that is who they would be able to remove if he had not already done so. And again, that may be a moot point. Now, if parties remain in possession, the landlord has new rights at that point if they need to still remove parties who were not covered by the current eviction order. And nothing prevents the landlord from going forth with that. And I'd say for our landlord, if you're unaware or unclear about what to do when you don't quite know who another party is, or you believe you have a squatter, please check into the Texas Property Code. In fact, there's some new updates to those statutes specifically in those provisions, okay? There's even new motions and methods out there for that. If parties voluntarily come to an agreement, then that takes care of it that way. All right. Mr. Aguilar, did you have any questions?
Can you repeat that part again, Aseline? Since the rate of possession will be awarded after
That's
the
right. So at the end
appeal.
of the appeals period, so everyone has to wait at least 5 days to see if anyone appeals, right? And also, y'all can talk to each other. If y'all come to some agreement, y'all can let me know by the end of the 5 days that, you know, y'all have worked it out and you don't need an eviction. That's between y'all. But if no one takes any action, Mr. Aguilar, Lone Ranger on day 6 could seek a writ of possession from the court. And once it's issued, the constable would post a notice, that would be posted on site and then notified to Mr. Aseline. And if he has not removed, you would then have the ability to go in and remove him and his possessions. But again, that's going to be a limited writ of possession. So maybe if you win, you can contact an attorney and learn where you think your lines rely with that. But you have to wait at least the 5 days.
Can I say something?
Yes, Mr. Aseline, I'm actually going to give you a chance to ask questions as well.
Yeah, I never lived in the property. I
Not
know I'm
required
the owner.
for them to evict you because it's a foreclosure eviction, sir. So
Yeah.
it's
I understand, but what I don't understand is that the person that actually lived there is right here, and I need to pay all the fees for not even living in the property, and he's partner in the company.
Please call a lawyer about what to do in that situation, sir. I can't.
Oh,
give you
we're already in the process of taking
Okay.
care of that situation in general. So
Well, that is certainly something that
May I
may give rise to
speak?
things. Mr. Guimond, I see you raise your hand. I will see if I can answer a question. I get a caveat. You're not a party to the case, but what was the question, sir?
Yeah, I would like to put on the record Roberts and Zachary Lofton's dishonesty here. They said the loan payment is $7,000. It is not. The loan payment is $5,400 to $5,600 monthly.
Okay.
On top of that, they increased the cost of the monthly payment to $18,000.
Y'all, Mr. Guimond, I appreciate that. I got to get to the rest of my docket, okay? We've spent a good amount of time with all the parties trying to give y'all information and direct you where you need to go. All parties are excused. Again, judgment is for possession and cost of court. Either party can appeal within 5 days. Appeal bond of $1,500, monthly rent of $250. All right. Thank you very much. And for our translator today, thank you as well, Ms. Karachi. You are all excused from court. All right.